Hello and welcome everyone to our session today, which is Div 7A and UPEs after the full federal court decision on Bendel, brought to you live by Tax Nuggets Academy. I'm Joyce and I'm your host for today. Welcome back to our subscribers, our Nuggeteers, as we like to call y'all. Thank you so much for joining us. And for those that are not our subscribers, welcome. If this is your first event for you, it's great to have you with us. So a couple of housekeeping things before we begin. The chat is open, so feel free to say hi, how you're doing. You know, anyone calling in from the north, Queensland, New South Wales, hang in there. Hope everything is as good as it can be. Yeah, so hopefully it's not too bad with the cyclone. And the Q&As are also open. We're taking questions throughout and we'll try to answer them as we go along if they are timely, but otherwise we'll address them towards the end. And I will look out for it as well. Please put it into the Q&A and not the chat so that I can get Daniel to respond. This session is being recorded and recordings are available for our VIP and team subscribers. So just very quickly, for those that are new to us, we are a tax training platform for SME accountants, and we're subscription-based like Netflix or You Can Eat platform. So for just $50 per person per month, you can access our live events, of which we have about 5 a week, and also our entire catalog of recordings of all our previous live events. So unlimited access. That includes monthly tax updates, special topics, and also programs like a graduate program, FBT program. The next one coming up is on company tax fundamentals, which starts next month. So do check us out, taxnuggetacademy.com.au, or just Google us. Introducing our instructor for today. He is the director of Birchstone Legal Group, specializing in private groups, restructuring, and complex tax advice. So please put your hands, your emoji hands together to give a very warm welcome to Daniel Toporski.
Thanks, Joyce.
Hi, Daniel. How are you?
Very good, very good. How are you, Joyce?
Very good. Huge case. Can't wait to get stuck into it. I understand the case is not that, interesting. I mean, the conclusion was very interesting, but also what do we do next, I think is going to be a big part of today. Is that right?
Yeah, agree. I think the case, it's pretty clear what the decision was of the full federal court. And I think what most people are interested in is, well, what does that mean going forward, particularly for sort of your FY23 UPEs that are going to have to be dealt with in the coming months with, your 24 tax returns being lodged.
Most of them are due like 15th May, like when a decision needs to be made. Is that right?
Exactly, yeah. Yeah, some May, but yeah, most 15 May.
Very timely then. So what's on
Okay.
the agenda?
Yes. So the agenda today, we're going to go through, we're going to start just with a bit of a background on Div 7A UPEs, just a very basics, just to make sure everyone understands like how we've got to where we are now, and we're all on the same page. Then we'll look at the full federal court decision. As we said, the decision's quite clear, so we won't spend too long dwelling on that. And rather, we'll look at like what's next. So is there likely to be an ATO appeal or legislative amendments to Div 7A? And then we'll look at the ATO's approach. They've got the interim decision impact statement, which was issued following the AAT decision. So will that be updated and when? And then we'll look at, well, what do we do now? So as we said, talking about those FY23 UPEs. And what about the historical ones? Is there anything we can or should be doing with those? Then we'll just look at a couple of other sort of risk areas, and they're really around subdivisions EA and EB, and also Section 100A. So even though the court has said that a UPE to a corporate beneficiary is not a loan for Div 7A, there's potentially other ways that the Commissioner might seek to tax such arrangements, and we'll look at those two in particular. Okay,
Sounds good.
let's get into it.
Just before we get into it, we will have a prize giveaway towards the end. for the best hashtag. So don't put your best hashtag just yet. We'll wait right until the end. I'll let you know when. And then Daniel will be the one to choose the best hashtag. And you, if you're chosen, then you will win a limited edition personalized mug, which looks like that. Maybe have it in your office, not at home, in case you have kids. But yeah, my kid's starting to read, so I hide it.
Yes.
Over to you, Daniel.
Okay. Yep. So Division 7A and UPE refresher, just some very basic Div 7A concepts. So Div 7A can apply to payments from a private company to a shareholder or associate of that private company. Can apply to loans that are made from a private company to a shareholder or associate of the shareholder, and can apply to forgiven debts that are owed by a shareholder to the company. So today we're really, and this Bendel is really focused on loans. So generally, when we have a loan for Div 7A, and on the next slide we'll talk about what that means. To prevent that giving rise to a deemed dividend, we need to either repay the loan before the lodgement day for the year in which the loan was made, so either full repayment, or we put the loan on a complying Division 7A loan agreement in accordance with Section 109N. And then once we've done that, we've got an obligation to make minimum yearly repayments for 30 June for the next 7 or 25 years, depending on what term the loan is. So that's good. It's worth noting just as well, because we'll note here, and we'll come back to it later on, that we've got Div 7A applies to loans, and it also applies to the forgiveness of debts. There's a distinction drawn in the legislation between a loan and a debt. So a loan, a loan is a type of debt, but there can be other debts that are not loans. So that we'll come back to that as we go through the court's decision. So I said we'd look at what loan means, and so loan takes its ordinary definition, but it includes these additional things which are listed in the legislation. And the ones that are particularly relevant for our discussion today is the inclusions in paragraph B and D. So the words any form of financial accommodation. Really, the court was looking at in Bendel what that actually meant, and was that broad enough to capture an unpaid present entitlement? And then essentially, in similar terms, a transaction, whatever its terms or form, which in substance affects a loan of money. So really, that's when we're looking at whether a UPE is a loan for Div 7A, no one's really arguing that it falls within the ordinary concept of a loan, or the argument was around whether it fell within these bolded extensions to the definition. Okay, so UPE, I've said a UPE, unpaid present entitlement, a few times. I'm sure most people know what it is, but just in case. The first, a UPE will basically arise where two things happen. First, the trustee of a trust confers a present entitlement of income or capital of a trust in favour of a beneficiary. And in the context of Div 7A, we're concerned about entitlements that are created in favour of corporate beneficiaries, companies. And then, so that entitlement's created often by your sort of year-end distributions. That's how you create that entitlement generally. And once that's done, then if there's no step taken to satisfy that entitlement, so it remains unpaid, it basically becomes an unpaid present entitlement, as the phrase suggests. So that's really what we're looking at here today. Trust has made a distribution of income to the private company, hasn't paid it. ATO says that's a loan. Federal Court was asked to determine, is it actually a loan or is it not? Okay, so we've looked at the background of what a loan is, what a UPE is. The ATO has changed its approach over the years concerning whether a UPE is in fact a loan. So before 16 December 2009, the ATO's view was that a UPE to a corporate beneficiary was not a loan for Div 7A purposes. And so if you're looking for your financial statements, you'll see these pre-16 2009 quarantine loans. They've been quarantined because the ATO's view up to that time was not a loan. 16 December, their view changed. they released the drafts of what became TR 2010/3 and PSLA 2010/4, where the commissioner took his revised approach, his new approach, that a UPE could be would give rise to financial accommodation and therefore be a loan for the purposes of Div 7A. And if you wanted to prevent uh, uh, negative consequences under Div 7A, so deemed dividends, that UPE either had to be put on complying Division 7A loan terms, or it could be subject to a subtrust that complied with some of the safe harbour arrangements in the PSLA, which broadly were sort of your 7 or 10-year interest-only loan, with the intention that the principal would be repaid at the end of that 7 or 10-year period. So that's what happened between 2009 to 2022. And then the Commission's view again changed in 30 June 2022 with the release of TD 2022 11. And in that case, his view became even more stricter. His former view that subtrusts that complied with the PSLA were effective to stop UPE giving rise to financial accommodation. He no longer took the view that was sufficient. Instead, and I've got the summary here of what and this is still the ATO's current position. Effectively, he now says that UPEs have to be converted to Div 7A loans, and subtrusts, except what I've referred to as a strict subtrust, are not effective to prevent financial accommodation from arising. And by strict subtrust, what we're really referring to is essentially the funds that are held in that subtrust are held solely for the sole corporate beneficiary. So they aren't intermingled with other trust funds. They're essentially put in a bank account for the benefit of the private beneficiary, private company beneficiary. And I say, if you're going to do that, you might as well just pay it to the corporate beneficiary. So he said that once you had that UPE, it was going to give rise to financial accommodation. The question is then, when did it arise? Well, it arose when both the private company had knowledge of the amount and having knowledge didn't demand repayment of that amount. So on the next slide, there's a bit of a time frame for how the sort of timing works. So, and this is relevant to where, like this example here, which is from the TD, is exactly relevant to the UPEs that are coming up now. So, so UPE that was created in the 2023 financial year, that the Commissioner says would give rise to financial accommodation sometime in the subsequent year, so FY24. They've got 1 August 23 on that chart. And that's when the private company was, the income was determined. The private company then knew what amount of income it could call on, but yet didn't call on that income. So that's when the loan arose. The loan having arisen in the 24 year meant by lodgement day of the company's 24 return, which here is 15 May 25. That's when the company would need to basically enter into a complying loan agreement. And the first repayment would then be by 30 June of this year of 25. So that's a sort of whirlwind summary of where we've got to in the last 15 years or so.
And we've got about 2.5 months to figure out whether we should put a complying loan agreement in place.
Yeah, are we going to follow this, or are we going to do something different? And that's what we'll get to. But before we get to that, Joyce, we might just have a bit of a look at the Bendel decision.
Absolutely.
Okay, so I've got a summary down here. I was tempted just to put this slide in, but we will go through a bit more detail. But it's essentially, if you take nothing else away from the case, this is all you need to understand. So this is essentially the reasoning of the court. So it says a loan for Div 7A purposes essentially requires a payment by the company with an obligation to repay. And then because the UPE doesn't involve a payment by the company, or the UPE is just arisen by the trustee exercising its discretion to confer a present entitlement on the company hasn't paid any amount. The trust has an obligation to pay the UPE, but not the obligation to repay anything because nothing was paid in the first place. And so quite simply, according to the full federal court, the UPE is not a loan for Div 7A purposes. This was it was full federal court, 3 judges, unanimous judgment. So you combine that plus the 2 tribunal members. So you've had 5 um, federal court judges or tribunal members hear the matter, and all have decided that it's not a UPE is not a loan. And that has, as we've just seen, has overturned this 15 odd years of the ATO administrative practice. Which
Wow.
this is why this case has generated so much sort of interest.
It's crazy. Anyway, I love the third dot point. I think it's so poetic. It's like the trust has an obligation to pay, but it's not an obligation to repay.
And when you look at it, it's quite simple. When you go back to legislation, yeah, that was why was there any dispute about that in the first place? But easy with the benefit of hindsight.
They only
Uh,
got it wrong for 15 years, the ATO.
yes. But we can talk about what they should have done instead. But let's go through the case in a little bit more detail than that. So I'll just simply go through the facts, and the facts are like relatively these are vanilla facts. You couldn't find pretty much a much more vanilla set of facts than these. So you've got a discretionary trust that's distributed large, significant amounts of profit or income across multiple income years to a corporate beneficiary. So you see Stephen Bendel, 2005 discretionary trust distributing to Gleeman Investments Proprietary Limited. There were also some distributions to Mr. Bendel in that time, but particularly the distributions that were made to the company, they were the company didn't call for those payments, and Gleeman didn't. The trust didn't set aside those amounts or didn't pay them to. It didn't do anything. Those funds just remained. Well, some remained in the trust. Some arguably went out to Mr. Bendel, but yeah, there were no payments. The UPE to the company remained unpaid. Was to the extent there would have been some. The company would have had tax to pay. The trust paid the company's tax. So some of the funds were used for that purpose, but the balance, none of that was paid across to the company.
Quite the typical scenario.
Nothing unusual. As I said, very vanilla, very vanilla. And also relevant here is that both the trust and the company were controlled by the same person, Mr. Bendel. So what did the ATO do? Well, the ATO determined that the amount that remained unpaid to the company to the company's lodgement day, that resulted in the company having made a loan to the trust, that the UPE was financial accommodation, falling within the definition of a loan, and then consistent with its views in its taxation TR 2010-3 and now more recently 2022-11. Their views in those determinations determined that that was a loan and therefore gave rise to a deemed dividend. And because it gave rise to a deemed dividend because there was no loan agreement put in place. And so they assessed, the beneficiaries, so it would be the company itself and Mr. Bendel on deemed dividends that arose due to the fact that the UPE was not itself put on a complying loan agreement. As a result, deemed dividends arose. Those deemed dividends went back to the trust, and there was therefore assessed on that. Okay, so the taxpayer then objected to that the amended assessments. The objection was denied, and then it was appealed to the taxpayer appealed to the Administrative Appeals Tribunal, as it then was, and that appeal was successful. And the tribunal holding that the UPE did not give rise to a loan within the defined term, and then the ATO then appealed to the full federal court, and that's where we are now. So I'll briefly go through the arguments that the commissioner ran, the taxpayer ran, and then what the court found. So the commissioner essentially argued that the tribunal didn't consider the text of the legislation and asked itself the wrong question. It said, are UPEs loans rather than do the UPEs fall within the definition that's defined in section 109D3? they argue that the tribunal failed to give effect to the ordinary and plain meaning of the word financial accommodation. And they referred to a number of judicial sort of decisions in other contexts where the phrase financial accommodation used, for example, in the Corporations Act, and in those other contexts, is given a very broad meaning, as you can see on the screen, can include provision of a guarantee, for example. So, yeah, but the court, so that was their argument. They said, look, this gives broad meaning. It's in the other context, you should adopt a similar context definition in the context of Div 7A. Commissioner also argued that the tribunal shouldn't have focused on subdivision EA as much, as that had a sort of different sphere of operation to Section 109D. They said subdivision EA dealt with basically payments, loans, or forgiven debts that are made by the trustee of a trust. 109D is dealing with payments from a company. They're different. One shouldn't affect the interpretation of the other. And then the final sort of thing he argued was that the commissioner failed to consider the legislative purpose of Division 7A to ensure that private companies cannot make tax-free distributions to their shareholders or associates. And he said that effectively by not treating a UPE as a loan, essentially funds tax profits of the company, which are the distributions that were made to the company became profit of the company. That profit was essentially enjoyed by an associate of the shareholder of the company in a tax-free form. So that's essentially the purpose. This was defeating the purpose of Div 7A was essentially his argument.
A little bit grasping, I feel, the last one, but got to
Yes.
chuck it in there.
Well, you look at the taxpayers' arguments, and they're quite simple. Well, they say Section 100D requires some positive act by the private company. We'll look at the clause again on the section on the next page, but it talks about requires there's an advance of funds, a provision of credit, a payment, a transact, like things that require something to happen. Whereas here, what happened is in fact nothing happens.
Yeah.
So
By doing nothing, the company
yeah.
has made a loan, basically, by not rejecting the UPE.
Exactly. Um, they refer to this concept of paid but not repaid, and they in fact said they referred to subdivisions EA and EB, and instead of how the commissioner tried to frame it, instead framed it, well, look, that clearly there was an intention to deal with UPEs under EA and EB. That's the reason why they shouldn't be included in the context of 109D. You don't put a UPE within the meaning of a loan in 109D, because if you do, you've got these other provisions over the side that deal with the same thing, and you've got potential double overlap.
Yes.
Which for me has always been a difficulty in the commissioner's interpretation for a UPA being a loan. How you reconcile those?
Yep. And we will be talking about EA towards the end, so you will really need to understand that later.
We will. Okay, so the text of the section, I've just bolded some, particularly if you look at the operative section. So we looked at subsection 3 before, which is the definition of a loan. But if you look at the operative section and look at the words that are bolded, it requires that the private company makes a loan to the entity during the current year, and that loan is not fully repaid before the lodgement day for the current year. So when you read that in hindsight, well, look there, that makes how is a UPE making a loan, and how is not paying the UPE got anything to do with it being repaid? So I think, yeah, I think that's the text for the legislation sort of stands in its own right. Okay, so just briefly, what was the court's decision? Well, it basically agreed with the tribunal's decision, but not exactly for the same reasons. There was some nuance differences in the reasons. It gave a lot of focus around statutory interpretation, and in looking back to the sort of the text and the provisions, context and purpose, when finding that a UPA was not a loan. And it said the definition of a loan, unlike what the commissioner argued, should not be given a wide construction, not as broad as what it was in a corporate law context, which had sort of a different purpose than what Div 7A had, and again referred back to the concepts of a repayment. There was a bit of this might be a little bit this might be. I might make this point. There was a lot of talk about it, whether it was a debtor-creditor relationship between the company and the trust, and the taxpayer had actually conceded in this case that it was a debtor-creditor relationship. But the court said, well, that's not enough. Like you can have a debtor-creditor relationship, um, but not all debtor-creditor relationships are loans.
Mm.
Debtor-credit relationship is a broader term that encompasses other things that are not a loan, such as, in this case, a UPE. So you can't simply say, hey, we have a debtor-creditor relationship, therefore we have a loan for Div 7A.
Mm-hmm.
And that's where I said before as well, the court highlighted that Div 7A in fact draws a distinction between a debt and a loan. You've got 109F that deals with the forgiveness of a debt, um, not the not the forgiveness of a loan. A loan, in fact, the loan is what is dealt with in 109D. So there's a difference in the legislation. It contemplates there being potentially having different meanings between the two terms.
Yep.
And finally, they said, like, their interpretation didn't give rise to absurd or irrational outcomes, which they said the commissioner's outcome interpretation would, and like double taxation potentially under Subdivision EA and Div 7A. So that in a nutshell is the commissioner's the full court's decision. And as I said, the summary, it's got to be a repayment of amount, not a payment. So let's look at what's next, and then we'll go
Right.
to, yep.
Tell us what to do,
What to do? What
Daniel.
to do? Well, before we
What to
get that,
do?
let's go through what's next, because that does impact on what we do.
Yep.
So that was the full federal court. The ATO has the opportunity to make an application for special leave to the High Court. So you don't have an automatic right to appeal to the High Court. You have to apply for special leave. And they've got until 19 March to do that. So a couple of weeks away. I think it's likely that they will apply for special leave. Probably a couple of reasons for that. One, if they want to push for legislative amendment to the section, I think Treasury will want to see that, to get Treasury on board for the legislative amendment. They want to see that the ATO sort of pursue this to the highest court, and so I think that's one reason they will at least apply for special leave. And if they do that as well, then the need to sort of approach any sort of legislative amendment can be pushed until after the federal election, because the federal election is coming up, Joyce, in the next, when's it? It needs to come up sometime before June, I think. This will probably, a special leave application, we probably are unlikely to know the application outcome until sometime after June. So I think for that reason, I think a special leave application is likely, but I don't think it's likely to be allowed. And because I mean, these things are always difficult, but I think the fact that we have a very strong, I mean, you've had five judges or members determine it. They've all determined that the commissioner is wrong. I think the court may well just say, look, we hear it. They often deny special leave applications for a number of reasons, but one of them will be because the prospects of success they're just not there. We don't think there's sufficient prospects of success to warrant special leave. So if I was to be a betting person, I think there will be an application, but that'll be denied. We'll see if that ends up being correct or not.
Yeah, but can I just ask? Now
Yeah.
we got a full federal court decision that is actually binding. Yeah, like we can use that as an argument.
Yes, yes, it is binding authority. Yes.
Yes. Yep. Amazing.
I mean, we can talk about the ATID, what the ATO is going to do. We'll wait until we get to about that, whether they're going to follow the full federal court decision in the interim. That I think is a interesting question, which we don't know the answer to yet. But before we get there, we'll just look at what is I guess another option is, well, what's next? Well, there could be a legislative amendment to the section. And the law could be amended so that UPEs are expressly brought within the concept of loans. Now, the question would be, well, if they're going to make such an amendment, well, would they make such an amendment? There's obviously a bunch of political sort of considerations to consider there. including like depends on who wins the election, and how strong that win is. If it's, I mean, if you end up with a hung parliament, I can't see it might be difficult for one of the parties to get. Yeah, if they need to rely on like the crossbenchers or the Greens to get this across, I suspect this might be yeah, might be difficult to get the minor parties across on this. But so we'll see whether this ever becomes a possibility. But
Mhm.
if it does, the question would this be retrospective or would this just have a prospective application? Obviously, as
Mhm.
taxpayers, we would say it should only be prospective. But if we look back to in time to 2018 when the Treasury released its consultation paper on amendments.
Wow, that was such a long time ago.
No. And as part of that, you can see in the bits highlighted, one of the amendments that were being considered was clarification that unpaid present entitlements come within the scope of Div 7A. So it's very express there. They said there that the amendments would apply from 1 July 19. That's something that got pushed back to 1 July 20 in the subsequent budget. And then further, it was further delayed. And so they said it was going to take effect from the date on or after rural assent. So you'd hope that if it ever comes across that they stick to that. But look, there is something there that says, look, back in 2018, we said we are going to do this.
Yeah, I doubt it'll be retrospective. I think the furor
You would hope
will be
not.
too much.
You'd hope not. The other question is, well, if they do amend, what are they? I don't think they could just amend this one thing. They have to amend at least broader parts of Div 7A to deal with the overlap between subdivisions EA and EB, which, as we said, we'll get to in a second. So it'll be interesting to see if they go down this path.
Yep. This is the consultation paper that recommended the 10-year loan. Is that
Correct.
right?
Yes,
And
yes,
then, yeah.
yes. And they're
Yep.
going to have a self-assessment for 109 IB, and there were some good things in there that were
Hmm.
good,
Hmm.
but you know, it's actually come into effect.
Yep.
Um, So I guess the third option is, well, first option, appeal. And these aren't necessarily mutually exclusive. Multiple of these options could happen. Second is legislative amendment. The third is, will the HS accept the decision, whether that becomes willingly or unwillingly, because they don't get special leave and they can't get the parliament to change the law. They may need to accept the decision. And if that's the case, the ATM may seek to rely on other provisions to tax arrangements that involve UPEs where they think there's been some mischief. And they are, again, we'll look at them in more detail shortly, subdivisions EA and EB, section 100A, and then there's also part 4A, which was applied in Guardian's case. To the ATO one and part 4A in Guardian. I suspect most sort of just corporate beneficiary vanilla cases won't involve part 4A, but if there's more unusual facts like we saw in Guardian where there was a distribution to a private company, and then the private company paid a dividend back to the trust, which was then flowed out to a non-resident overseas. If you saw sort of more elaborate type arrangements like that, then we might see part 4A potentially being applied by the commissioner as well.
Yep.
Okay. And the last thing I wanted to talk about in this section was the ATO's decision impact statement. And that was issued following the ATO decision back in November 23. And it's likely they will update that decision impact statement after the ATO makes a special leave application or decides that it won't. So hopefully in the next couple of weeks, we have an updated decision impact statement. And that should tell us what the ATO is going to do in the interim. Under the previous one, they said they were going to continue to administer the law in accordance with their guidance until the appeal process is finalised. So if I'm reading that literally, appeal process is finalised, they're not just talking about the one appeal to the federal court. They're talking about the appeal process, which would include also an application for special leave to the High Court. So, but if you read that literally, I'd suggest they're going to continue to administer the law as I see it, notwithstanding that there's now a full federal court decision that goes against their practice.
And they're probably going to have like, yeah, massive words about Section 100A. Yes,
Exactly.
exactly.
Yes. Yes. So that warning was very bold in the immediate previous interim decision impact statement. They're
Mhm.
saying, well, in addition to 109D, there's other ways in which we could tax these UPEs, and potentially 100A is one of them.
Mm.
Okay. So we will now look at what do we do. So this, I think, is the question most people have. And the way we've sort of looked at it is we think there's kind of, well, there's two broad options. So, and this assumes the commissioner continues to administer the law in line with TD 2022-11. If he comes up with something else in his interim decision impact statement, then this might need to be revisited. But you've essentially got two options. One year they comply with what the commissioner says, so you continue to administer it in line with his tax determination. And in which case you need to either pay the UPE by the lodgement day for, if we're talking about your FY23 UPE, by your lodgement day for your FY24 return, which, as we said, is coming up for most people probably in May 25.
Mhm.
To either pay the UPE or put in place a complying Div 7A loan agreement, and then start making minimum repayments by 30 June. Question then, which we'll come back to, is if you do that, you put in place your compliant loan agreement, are you then locked into the loan agreement, even if Bendel is ultimately upheld, so the High Court doesn't grant special leave or does grant it and dismisses the appeal? So that's option one. Option two is you basically follow the full federal court's decision. Treat the UPE as not a loan. It's not a loan. We're not going to put it on a compliant loan agreement. Instead, we'll do nothing. Just leave it as is. We will need to we'll need to consider, if you want to do nothing. A lot of taxpayers actually have facility agreements in place, and think we'll come to that in a coming slide. And these facility agreements will just purport to capture anything that sort of falls within the definition of Div 7A. So a loan for Div 7A. So if you don't want that facility agreement to apply, you might actually have to take some positive action in terminating that facility agreement, so it doesn't apply to future amounts. Because if you do nothing, you've got a facility agreement that's just meant to capture loans as they come up, and this will arguably capture the UPE as it comes up, if it ends up being that a UPE is a loan.
Yeah, the wording in the facility agreement has to be really scrutinized.
Yeah, and we've got a slide
Yeah.
where I'm going to go through that because I think that's an important point. The other thing you need to do if you're not going to treat the UPE as a loan is you're going to have to comply with subdivisions EA and EB.
Mhm.
As we'll see, essentially why we've treated the UPE, if you've treated UPEs as loans, you've essentially not had to worry about EA or EB for like basically since you've been converting UPEs to loans. But if you no longer do that, then those provisions come into play, and you really need to think about whether they're going to be triggered. The potential outcomes, I guess, of taking that approach is you've got your 100A risk. So if he doesn't tax you, potentially there's a 100A risk, so the 100A could apply, and we'll to the UPM, we'll look at that. And then there's also, I guess, if the commissioner is ultimately successful and the High Court determines that a UPE is a loan, then you haven't complied with Div 7A because you haven't put it on a loan agreement or paid it. But you'd like to think in that case, if that happens, you've got a good argument that 109RB should apply, and you should be able to fix up the mistake without a deemed dividend arising.
Yeah. What's a 109 RB? Is that where you apply for?
Yeah, so that's where there's been an honest mistake or inadvertent omission, and you
Yep.
seek the commissioner's discretion to disregard the Division 7A implications of that honest mistake or inadvertent omission. So here the honest mistake would be failing to put the UPE on a loan agreement and failing to make minimum yearly repayments.
But it's not really an honest mistake. It's kind of just a mistake because you relied on a full federal court decision,
No,
you know?
I mean, I think relying like I think the mistake is you thought the law was that a UPE was on a loan. You've done that based on a unanimous full federal court decision.
Mm.
Struggle to see how someone could say that. They could say that's not an honest.
Okay. Yep. Understand.
Yep. Yep.
Okay. Hmm.
Probably the other thing, if you no, we'll come back to that. We'll come back to that. Okay.
Yep.
So they're broad options. What about the historical UPEs? So if you haven't complied with the ATO's view before, so you haven't been putting your loans on complying loan agreements, or you haven't been putting on subtrust prior to 22, then and you've been assessed on a deemed dividend by the commissioner, then clearly you should object. And I'd be doing that even if you're strictly outside the time limit. Commissioner has an ability to grant an extension of time to put an amendment in, an objection in. So yeah, that I would definitely do. That's clear. But what if instead of not complying and haven't been assessed on the Div 7A, what you've done is you've complied with the commissioner's view, you've put a complying loan agreement in place, or you've held the amount under a subtrust arrangement. I guess my two broad questions are: can you back out of it? And assuming you can, do you want to back out of it? So the first question: can we back out of the loan agreement we've put in place or the subtrust arrangement? The first thing I'll be asking is: does the loan agreement actually cover the UPE? And this is where I think, as you said, Joyce, the words or the text of your loan agreement is going to be very important in determining whether it's caught. So if you go to the next slide, this is a definition I've pulled from a loan agreement on how it defines loan. And it defines loan as, you can see A, B, C, D. If you look back at section 109D3, they are an exact carbon copy of those
109D.
exactly the legislation.
109D3, yeah?
109D3, exactly,
Yeah.
yep. And then it purports to capture anything that falls within that's made before or after the date of this agreement, and which would cause the lender to be taken under section 109D to pay a dividend. So I think if you have one like this, I think you'd be pretty confident. Well, if you had this loan agreement in place and you thought your UPEs were covered, I think they're probably not covered under the loan agreement because of paragraph F there. Because if the UP is not in fact a loan, then it wouldn't give rise to a deemed dividend under Div 7A, and therefore it wouldn't be caught by this loan agreement.
Wow. It's almost like it can go back in time, and because it all relies on the interpretation of what 109D considers a loan. And so if that 109D definition keeps changing,
Yes.
then whether your UP is under a Div 7A complying loan will also keep changing.
Potentially, if you're I mean, some loan agreements are. Some people enter loan agreements with a specific amount each year. That's going to be different. But like a facility type agreement that just purports to capture any amounts lent, in this case, before and after that agreement's entered into. The one other thing I think might vary as well is this one had paragraph F, which specifically refers back to the definition or back to section 109D and whether it gives rise to a deemed dividend. There is potentially a different position if instead of paragraph F, that paragraph F wasn't there, and all you did is you repeated the words of 109D3. So you just had A, B, C, D, but the question would be, well, if you take those words outside the context of divs, it's no longer those words are no longer within the context of your Division 7A in the legislation. They're in a separate loan agreement, a different context. And as a court found in Bendel, you look at the same words in a different context, doesn't mean they mean the same things. But is there a risk that even though the words are the same as 109D, because it's in a different context, you could interpret your loan agreement differently? I don't know. It might be stretching it, but I think there's a question there around that. So you're going to have to determine, if you've got loan agreements in place, does your loan agreement capture a UPE?
Understand.
Based on the
Yeah.
wording.
So the key steps are, for historical UPEs, that is, first of all, go check your Div 7A complying loan agreement.
Yep. Does it actually
right? If it's quite the non-facility type, which is you've put an amount in there, that's a loan, then you pretty much can't do much about it. You're locked in. Is that right, Daniel?
Maybe.
Most.
This might become a fertile area for sort of advice and disputes around this. So,
but if it's the facility type with some wording that hinges on, the wording in 109D3, then you could be, yeah,
I,
more likely.
I think you're more likely to be
Suc-
out.
yeah.
I have put on the next slide, well, next to the next bullet point under that. So the first was, does the loan agreement actually cover the UPE? The second
Mm,
is, if not, has the agreement been has there been an agreement by conduct? So even though that the loan agreement maybe not doesn't technically apply because it doesn't meet the definition, have the fact that they've been complying with the repayments as if the loan agreement did apply, mean they've sort of amended the loan agreement through their conduct so that it does capture the UPE?
mm,
Possibly, possibly. Um,
mhm, mhm.
even then, I say, even if it has been covered by the loan agreement, what does that loan agreement actually? Does the loan agreement actually convert it to a loan? Um, and the reason I say that is, well, there's two reasons. One, the commissioner actually, in if you go back to TD 2211, he actually talks about whether you can sort of make a UP either subject to a complying loan agreement, or you can say the UP is in fact satisfied and replaced with a new loan. There's a subtle distinction there, whether you're just agreeing that the UPS remains on foot and you're just agreeing to make repayments. Well, I shouldn't even say payments to the UPE in a particular time period, as opposed to the UP ending and a new loan coming to existence.
Mm,
The other point there is, well, the full federal court said a loan is there's got to be a payment of amount and then an obligation to repay. How does this, by putting a loan agreement in place, create an obligation to repay? There still has been no payment in the first place. So I think
mhm.
there's a question around that. There's a lot of questions here, not really answers,
I can
unfortunately.
see a lot of lawyers coming in like seagulls, Daniel. There'll be a field day for
Yeah.
tax lawyers, I reckon.
And so I guess that boils down to the ultimate question. Well, can you then, like you said, possibly to back out of the loan agreement, and can it be terminated and the amount still be UPE, not be a loan? And I think that's going to depend on the sort of the things we just spoke about.
Yeah. So my key takeaway is if you're going to argue that your historical UPE is not a loan, you better
I think,
get your tax lawyers involved. Like
yeah,
it's complicated.
depending on the facts, I think it is arguable,
Yeah, yeah.
given the facts. My next question is about, do you want to argue that? And then you've got to, so I think you've got to look back and say, well, if it wasn't actually converted to a loan, the UP wasn't converted to a loan, have I got subdivision EA risks?
Mhm,
Like,
mhm,
is it actually better for me that there is a loan and I've complied with that, rather than having to look back and look, amounts have been, lent out to, yeah, other beneficiaries, and therefore I've got an EA risk. Um,
mm, mm.
and also, well, what about my Section 100A risk? I might, because we're going to look at 100A. If we comply with Div 7A, we probably don't have a 100A risk. But if we don't, then there's a risk 100A might apply.
Yep.
Okay. We've gone through that. Now how are we going for time, Joyce?
10 more minutes.
Okay. All right. Well, we'll go through EA and EB. We'll do it pretty quickly, and we'll do Section 100A. Then we'll have some time for some questions. So EA, these provisions have been in the Act, or various versions of it, for pretty much right back when the Act was implemented.
Mhm,
And these require there to be a UPE between a trust and a private company, and then that trust to have made a payment, made a loan to, or given a debt to the shareholder or associate of that company. So the way I consider it, once there's a UPE in place between a trust and a company, and there's some rules about, like, the timing can differ. The loan can come first, or the UPE can come first, and the loan after. But you need, at some stage, you need a UPE between a trust and a company. Once that happens, essentially you consider the trust as if it is a company, and the same things that would happen from a company between a shareholder can happen between the trust and the shareholder. So the trust makes a loan, that can give rise to a deemed dividend, unless it's put on complying loan terms. So that's essentially what EA is trying to do.
mhm.
But it doesn't say that. It says the UP between the trust and the company is not enough. You need a second thing, and that second thing is a payment from the trust to the shareholder, or a loan from the trust to the shareholder, or forgiven debt. So it's two things, not just a UPE.
Yep. Yep. It's kind of like you're enjoying the corporate tax rate, but then the cash and economic benefit has gone to somewhere else that is not a company.
Exactly.
Mhm.
Yep. Um, EB is similar, just involves when there's an interposition of trusts. I won't. There's two trusts, more than one trust between the yeah. One or more trusts between the trust making the payment to the shareholder and the private company that's made that has a UPE owing to it.
Yep.
And just for summarizing what we said before, previously it's had little application because all UPEs have been converted to loans, and the commissioner considers when you do that uh, yeah, Div 7A, well, 109 subdivisions EA and EB don't apply. But so they've only really had application to pre-09 UPEs and post-09 UPEs that were held as subtrusts. Um, if if all the UPEs have been converted to loans, we haven't had to worry about subdivision EA and EB. But if you don't convert your UPE to a loan going forward based on Bendel, you will need to look through and see if subdivisions EA and EB apply. And the most common way we see them applied is you look at you've got a beneficiary account that's owing to the company in the trust. So the trust owes the company money for its UPE, but then the trust has lent out money to like the individuals, and they've got overdrawn beneficiary balances. And when you see
Mhm.
that fact pattern, that is a classic fact pattern for EA and EB to potentially apply.
Yep.
Okay, so that's the summary there. So I think a lot more attention is going to be drawn on EA and EB. Then finally, we'll touch on some comments around 100A. And I've got my sort of checklist of things I go through when I'm looking at whether 100A applies. So we'll go through them in the context of a UPE to a corporate beneficiary and see whether we think 100A could apply to that. So with the UPE to a corporate beneficiary, was there a beneficiary not under a legal disability presently entitled to trust income? Well, yes, there is. The company is entitled to trust income, so that first element of 100A is met. Uh, was there an agreement, arrangement, or understanding? I'll read that within context with the next one. Was there an agreement, arrangement, or understanding that provided for a payment to or the provision of some other benefit for a person other than a beneficiary? So I would, in the context of an unpaid present entitlement, I think that is met. The agreement, arrangement, or understanding is that an amount being the unpaid entitlement that is not caught on by the company, and in doing so, the trustee, which is a person other than the beneficiary, it enjoys some other benefit, being the use of those funds while the company doesn't continue to call on the amount. So that's the person that benefits the trustee, and the benefit is by having continued use of the funds. So I think those additional two requirements of 100A are met.
Mhm.
Did the beneficiary's entitlement arise out of the agreement? That's not the timing question, and this was the point in Guardian, which is another 100A Part 4 case, looked at that, and in that case they said there was no agreement, arrangement, understanding that present entitlement arose out of, and that's because in that case there was no agreement at the time the present entitlement was created for there to, in that case, be a dividend back from the private company to the trust and then to flow on to Mr. Springer. Um, I'm not sure. I think in most cases this will be satisfied. I think in most cases there will be, at the time the present time is created, there will be an understanding between the controller will be generally the same of both, that we'll make this entitlement, but we're not going to pay it, and that
Mhm.
that I think is arguably enough. It's a bit different from Guardian as well, because Guardian required like a positive action. There was going to have to be a dividend by the private company. Here
Yep.
again, it's passive, it's just a non-calling. So I think it's maybe an easier threshold to get after over.
Yeah. And
Um,
even if you do it once, if you're doing it again next year,
yeah,
it's kind of like a pattern, and it's kind of like, yep, that's an agreement. Like you do it every year,
yeah.
right?
I mean,
Like you don't pay the UPE every year, so that's your agreement.
it is. Guardian happened 2 years in a row, and they said that wasn't enough.
Yeah.
I think
Okay.
Guardian has some
Okay.
peculiar facts that I think are not going to apply in most cases.
That's right. That's right. Mm.
The next element is was there a tax reducing purpose? And I think pretty clearly, I think the reason people distribute to a private company is to get the benefit of the corporate tax rate. You could easily just accumulate the income, but then you'd be paying tax to the top
Yep.
marginal tax rate. So why do you distribute to the corporate beneficiary is to get that tax reduction. So I think that bit will be easily met. The
Hmm.
one element of 100A that I'm not sure will be satisfied is the ordinary family or commercial dealing exception. I think when there's a loan in place, Div 7A loan, then you say that's a commercial arrangement, therefore 100A can't apply. But if you don't have the loan in place, I think there's a question about whether there is a ordinary family or commercial dealing.
Can it
Now,
be like a subtrust loan? Just commercial rates, but no strict minimum repayment potentially?
yes, well, there's actually some comments in. We'll get look at the HSPS or PCG on 100A, and there's some comments in there around that are exactly on point.
Hmm.
But before we get there, I just wanted to just highlight one phrase from Guardian, where the commissioner, basically commissioner's representative, basically said that the mere inclusion of a corporate beneficiary as an eligible beneficiary, and the fact that a distribution may be made to such a beneficiary, that would be sufficient to demonstrate that a dealing was not an ordinary family or commercial dealing. So you're saying that those two, the fact you've got a corporate beneficiary and the fact you've distributed to them, that in itself would be ordinary, an ordinary family or commercial dealing. I guess he doesn't go on to say, well, if you do that and then the distribution is not paid for a period of time, whether that then makes it unordinary. Uh, the issue, I mean, the issue with that is there's just no real good guidance on what ordinary family or commercial dealing is. So there's definitely an argument to say even if it remains unpaid and not put in the compliant loan terms, it should be ordinary. But there's no real guidance at all to you can hang your hat on to support that position.
Okay.
And the last point I just want to make, Joyce, we'll go to the PCG. So there is the example in the PCG, the green zone scenario 3B, which is meant to deal with distributions from a trust to a company. And so with the trust, the key requirements for this green zone scenario to apply is where the funds are retained by the trustee for more than 2 years. Of course, if it's less than 2 years, there's a separate exemption for that. So the trustee retains the funds for more than 2 years. The trustee needs to use those funds in essentially the business or acquire an income producing asset. That's the trustee working capital condition. But if it does that, and then if the terms on which the entitlement is made available for the trustee uh, is by way of loan on it says commercial terms, then that will be sufficient to fall within the green zone example. So I know in the diagram they've got section 109N, but if you look at the text of the scenario, they say is by way of loan on commercial terms, and then
Oh.
there's a footnote later on which actually says note there may be Div 7A consequences if these terms do not comply with section 109N. So they're clearly contemplating that the commercial terms may be something other than what is provided for in section 109N.
Hmm. Okay. Yep, yep,
So
yep.
there we go. So that's all I had, Joyce.
Yeah,
Um,
yeah. This is a good pickup. This is a good example.
yeah.
Amazing. Before we head into Q&A, yeah. So if you found this session helpful, do check us out. taxnuggesacademy.com.au. You can sign up for a free 10-day trial, and we also have team subscriptions for your whole firm. Right. Let's do the hashtag before we get into Q&A, because some people might need to duck out at 3 o'clock. All right. So next one is hashtag competition. So please, Daniel, open up your chat. I can see all the hashtags coming in and pick your favorite one.
No pressure. No pressure.
Best Bendel hashtag. Put it in the chat now.
Oh, I quite like Sharon's put ATO. Oops. I think that's a good one. I like that.
Okay.
What else have we got?
It's just nugget. Make sure you pay attention, okay? Because we need to get the person's name and email them later.
Dale's got
Maybe.
Bendel like Bendel. I like that's good.
Okay. Yeah. Yep. Who was that from?
That was from Dale.
Yep.
How many am I choosing?
Maybe choose three, and then we have shortlist three, and then you got to choose the winner.
Oh dear.
Oh, Bendel is the GOAT. Love it. Unpaid but not forgotten. Loving it, people.
I like. Oh yeah, unpaid but not forgotten. Yeah, I like that.
Any others?
I'm being
That's
overwhelmed.
enough. And then, okay, we shortlist three. Okay, from Sharon, ATO Oops, Adele, Bendit like Bendel, and Jerem, unpaid but not forgotten. All right, pick
I
the
think we'll go.
winner, Daniel.
I think we'll go unpaid but not forgotten.
Yay, Jerem Jerusalem, unpaid but not forgotten. There you go. We will reach out to you and get your address and get, what name you want on there, and we can change the emoji as well if you want. Amazing. Now heading up to Q&A. Got quite a number. I don't think we'll be able to go through all of them, but I'll just try and capture the really big ones. So I guess the first question I think is around accounting.
Yep. Yep.
Because you mentioned before just now as well, like it's still a creditor-debtor relationship. So how do we treat it in the trust accounts, a UPE? I mean, to a company or to any beneficiary, how do we treat it in the accounts?
So I mean, I don't know if the full court actually said the UPE was a debtor-creditor relationship.
Okay.
It was because the taxpayer conceded it for that for Bendel. It was the taxpayer did deny they accepted that it was in this particular case a debtor-creditor relationship, but the court didn't go as far as saying in every case a UPE would be a debtor-creditor relationship. But I think if it's shown as a liability on the balance sheet, it's more likely to be a debtor-creditor relationship. Whereas if you show it in the equity section of the balance sheet, I think that's more consistent with it not yet becoming a debtor-creditor relationship. At some stage, I think it does become a debtor-creditor relationship. Exactly when that is maybe not entirely clear. But definitely, if the trustee has recognised it as a liability in the balance sheet, that you're moving far closer towards it becoming a liability than not. If that makes sense.
Yeah. Have you seen UPEs just hanging around in the equity section? Is that common?
To be honest, I think most financial software, accounting softwares will put it as liabilities.
Yeah, it's quite uncommon to sit in the equity session. Yeah.
Yeah.
Okay.
But I don't see any reason why it couldn't.
Anyway, accounting question.
Don't ask the lawyer accounting questions.
Yeah. Cool. Mary's just wondering who wore Bendel's costs. I think there's a lot of curiosity around Steve Bendel. Like he's like such a hero for all of us. Yeah, we're just curious, I think. Do you know?
As I understand, it was test case funded. At least the federal court hearing was test case funded. I don't believe it was initially test case funded. So test case funding means that the ATO will cover. I'm not exactly sure. I don't know if it covers all the costs, but that will cover a portion of the costs. Probably on like what us lawyers would call like a party basis. But some of the costs will be borne by the ATO.
Stephen has asked, what about pre-2009 UPEs as part of, say, a rewrite or legislative change? Do you think that they will be brought in?
If I would go back to that 2018 consultation paper, there was one of the questions of that consultation paper is what should we do with the pre-09 UPEs? Should we bring them in, and if so, on what terms should they be brought in? So if there's a rewrite, I think there's some prospect that they might be brought in. You'd hope if they were going to be brought in, there'd be some concessionary period to give taxpayers time to adjust and sort of deal with the cash flow impacts. But again, there's a precedent in that 2018 consultation paper for them potentially being brought in.
Gina has asked, can you just repeat the classic fact pattern for subdivision EA?
So classic fact pattern is you've got a UPE between a trust and a company. So unpaid present time between trust and company, and then the trust then makes a payment, makes a loan, or if it gives a debt to a shareholder or associative shareholder of that private company to which the UPE is owed.
Yeah.
We go back on the slides, Joyce.
Your Assistant Nugget, can you go to slide 33, please?
So
Yep, that's
yep,
one.
there we go. UPE between trust and company, and uh, at the same time, or the timing is a little bit. The timing is not exactly right. It doesn't have to be exactly precisely the same timing, but roughly once that UPE is in place, then there's a payment, loan, or forgiven debt out to a shareholder or associate of that private company to which the UPE is owed.
Yep. And then Matthew was asked, what if the individual beneficiaries' balances are not overdrawn, but they still receive some drawings after the UPE is established, but they never overdraw?
That will be fine. That if they've been made entitled to income and all they're doing is getting paid out some or all of that income, that won't give rise to EA. It's only when there's an additional loan out or a payment that isn't basically the distribution of income can it be caught.
Okay. Bradley has asked, if you have a loan agreement that has those words in it, which will pull in any advance, and if you do a loan agreement each year for, I think, yeah, each amount of the UPE, then do you need a document that repudiates each loan agreement in place going forward?
So the fact pattern was you have a loan agreement that has the same words as what we had on the slide, but you do it.
That has the words which will pull in any advance. And if you did do a loan agreement each year for the UPE, and I think it's like quite specific, UPE is, the amount of the UPE becomes a Div 7A loan.
Yeah, I think
Yeah, I guess it's like, is there a way to get out of it? Like, can you put in a document that repudiates each loan agreement?
yeah, and I think so. I think if you've done that, the loan agreement, I don't think you've got the argument, so the loan agreement doesn't apply. If you've put the exact, like you've actually put the amount in and you refer to the specific UBE, so it's probably caught. The question is then, can you repudiate that or somehow terminate that? And then does it go back to does it go does it go back to being a UPE? Or the question might be, has actually entering into the loan agreement changed it from being a UPE in the first place?
Into a loan.
Has it changed to a loan, or is it still a UPE, but just there's now terms around when it has to be paid, the period over which it's going to be paid? So I think that these are the tricky questions that are going to come up. It's going to, depend precisely on what's been done and the words of the agreement.
Yep. Have any clients approached you on this, or they're all just still waiting until special leave?
I think no one's going to pull the trigger and do anything yet until at least special leave application.
Oh, okay. Yeah. It's just the timing is so bad. Like, we just got 2 months to work out what to do.
I mean, but the thing, I guess the one thing to get across is the time critical thing is what do we do? Not with the historical ones, we have time to deal with them once we know all the facts and where the special leave application lands. But the thing we have to decide now is what are we going to do for the FY23 UPEs? Are we going
to... Like, just from what I heard today, I feel like your recommendation would be to do like a facility type agreement thing potentially, that and then the wordings of that facility agreement is going to hinge on the 109D3.
I think definition? That's probably a good way of going. Yeah, I'm concerned about people that do nothing. You want to be very cautious that you've got a strong argument against 100A, and you haven't got any EA risks. I think if you're in doubt, it's better to put a facility agreement in place that potentially covers it, potentially doesn't, and you can probably argue it both ways in the future.
Yeah. Assistant Nugget, can you go to the final key takeaway slide? So so maybe just summarize everything again, Daniel. I guess for the FY23 UPEs, what would you do?
What would you do? So you've got to make a decision. Do you continue applying, or do you just follow the federal court and not do anything? I think a good middle ground is to have in place a facility agreement which arguably captures the UPE. Well, is worded in a way that will capture UPE if it is a loan, but will fall outside if it's not a loan.
Because it buys us time, right?
It buys us time. I mean, yes. I mean, technically, if it falls outside, the HA could argue, well, EA applies and 100A applies. But I can't see them practically doing that if you've got a loan agreement in place.
But also make sure that you're not, contravening subdivision EA. Don't go and then, send the money elsewhere, keep it in the trust.
Yep.
Yeah, keep it in the trust.
Yep. My approach is if you want to pay money out to beneficiaries, pay the money to the company and then flush it out. But I know in practice it doesn't. It's not. It's easier said than done, because money comes out during the year to the controllers,
The beneficiaries. Yeah. And then, don't forget to think about your 100A risks as well. Keeping in mind, go read the Guardian case. To see what your risks is compared to the Guardian case. But the Guardian case is pretty egregious, I think, compared to just the washing machine, arrangement, or the not paying out the UPE option.
Yeah.
Amazing. Thank you, people, for staying back. I'm sorry if we didn't get to your questions, but I think there's like 800 people online today. So those that are, subscribers, you can put in a comment under the video replay, and then we'll shoot it across to Daniel. Thank you so much, everyone, for joining us. Love all the emojis. And thank you so much, Daniel. One last round of applause to say thanks to Daniel. We'll see you all next time. Bye.